Next item of business is Stage 1 debate on motion 23243 in the name of Ash Denham on the Defamation and Malicious Publication Scotland Bill. Can I ask those who wish to speak in the debate to press the request to speak buttons, and I call on Ash Denham to speak to and move the motion for up to 10 minutes, please, Minister.
Thank you, Presiding Officer. It is now just over 11 months since this bill was introduced to Parliament, and the normal legislative process of this bill has been greatly impacted by circumstances forced upon us due to COVID-19. So I'd like to thank the Justice Committee and its clerks for their patient and hard work that have allowed this bill to progress. And I'm pleased to note that the committee recommends that the general principles be agreed to. This bill is different from those usually considered by the Justice Committee. It's largely the product of the Scottish Law Commission, which considered possible reforms of Scots law of defamation. The bill takes forward every substantive recommendation made, and I would like to thank the Commission for the work that it has put into this reform project. Given the rights affected by the bill, I want to make sure that, as far as possible, the provisions are something we as a Parliament can all agree upon. The law of defamation has to strike the right balance between two values that sometimes pull in opposite directions, and these are freedom of expression and protection of reputation, and both are fundamental human rights, and both are vitally important in modern democracy. The widespread use of social media means that we are all capable of creating content that can be easily shared and viewed, and this bill aims to make sure that our law of defamation is fit for the 21st century Scotland, with a clear and an accessible framework that balances these two rights. It brings defamation law up to date and it simplifies it. In some key areas, replacing and restating the existing law. And I'd like to turn to look at some of these key measures, beginning with the statutory definition of a defamatory statement. So other provisions in the bill set out what defamation is not, so it's important that we define what a defamatory statement is. And the common law definition, referred to most often by the courts, was set out in 1936, and this is a chance for this legislature to consider and to debate the definition. The bill takes the common law definition and it expresses it in modern language that is already familiar to the courts. The committee has heard evidence from those who are content, but also from some who have concerns. And it's normal for courts to consider previous case law as a matter of course, and I would expect them, when interpreting the new statutory definition, to do so where it is appropriate. But I will make this view clear in the explanatory notes to the bill, and I believe that this is the most appropriate way to signal to the courts and to users of the legislation that the statutory definition should be interpreted in line with the common law definition that we have today, and importantly, that the definition will evolve as and when case law develops, and I hope that that will allay some of the concerns around that. So the threshold test of serious harm introduced by this bill is another important provision. When a court finds a statement to have been defamatory, the law presumes that damage has been done. And I don't believe that this appropriately balances protection of reputation and freedom of expression. And I am clear that if a person says that their reputation has been unfairly damaged by a defamatory statement, then they should have to prove, at least to a minimum standard, how it's been damaged. Some who are opposed to this have referred to it as an English solution to an English problem, but I disagree very strongly with that viewpoint. The Scottish Law Commission took a broad look at Scots law of defamation and recommended that the threshold test of serious harm be introduced. I don't believe that the Commission would have made this recommendation if they didn't think that it was appropriate, and I welcome the committee's view that the test should be retained. In England and Wales, public bodies are prohibited from raising a defamation action, and there has been no decided case in Scotland that affirms this so-called Derbyshire Principle. The bill codifies this principle, and I believe that it is of the highest public importance that a democratically elected governmental body should be open to uninhibited public criticism. I've tried to come up with a sensible and also a flexible definition for the Derbyshire Principle, but crucially does not expand on the common law. and the drafting borrows from Section 6 of the Human Rights Act of 1998. It's been discussed by the courts for over 20 years, and it will give practitioners a good base from which to advise their clients. I've listened to a range of views on this matter and to the committee's recommendation, and I am willing to work with members to ensure that we get a provision that codifies the Derbyshire Principle as it exists at the moment, one that is clear but also flexible. The bill restricts liability for a defamatory statement to those who are primarily responsible for its publication. Currently, secondary publishers like a library... I will.
Liam Kerr.
Very grateful. Just on that previous point, where does the Minister stand on the... she was talking about the liability on public bodies. Where is the Minister's thought process on private companies providing to the public body, whether that should be extended to them?
Ash Denham.
Well, that is exactly what I'm meaning by the use of the word flexible. So we can see that public-private provision clearly has moved on quite a lot in the last 30 years. And so it's important that we have retained that flexibility to allow us to perhaps settle some hard cases that might present themselves in the future. Presiding officer, a bookseller or a website operator can be held liable for content that they are not actively responsible for, and private companies face a choice: remove potentially legitimate content or be held liable for damages. And in my view, it should be for the court to decide whether a statement is defamatory and not private companies. And I welcome the committee's view on this, that secondary publishers should be excluded from liability in the circumstances outlined in the bill. I know that committee members are concerned about online defamation, and I set out my response to the committee's report, the process and potential costs of removing such material, and I hope this eases any concern. The main defences to a defamation action are brought together: reforming existing statute and the case of the public interest defence codifying the common law. The committee recommends that courts should have the ability to refer to previous case law when interpreting these statutory defences, and I will ensure that the explanatory notes clearly state our expectation that a court, when interpreting the new statutory defences, take into account case law on common law defences where that is appropriate. And the bill largely restates the offer of amends procedure, and this is a useful process by which those who admit that they have defamed someone can avoid legal proceedings. As part of an offer of amends, an offer of compensation is made together with an apology and a correction. And where the amount of compensation cannot be agreed between the parties, the court is asked to decide this instead. The committee has heard conflicting views on whether the bill still allows this offer of compensation to be discounted by the court. And so, in light of this, I'm pleased to commit to bringing forward amendment at stage 2 to clarify. The bill reforms the law on malicious publication, and in order to succeed, the pursuer must show that the statement complained of was made with malice. The definition in the bill reflects the common law for similar types of action, but the committee has concerns, and I'm happy to bring forward an amendment at stage 2 to reflect the committee's recommendation. 2 other matters regarding malicious publication were also raised, and that is the available defences and the liability of secondary publishers. And in order to make these issues clear, I will amend the explanatory notes to state my view that a malicious publication action could not be raised against a secondary publisher, and I set out clearly that the defences of truth, absolute privilege and honest opinion are intended to apply. And I'd like to finish with the matter of limitation in the bill. A principal aim of limitation is that litigation should proceed promptly. And I believe that where someone suffers damage to the reputation, they are usually aware of this at an early stage. And that's why I agree with the Commission that 1 year is sufficient to assess any damage and to prepare for litigation. The court has the discretion to allow litigation to proceed out with the 1 year period where it considers that it's equitable to do so. And I would suggest that a statement that comes to the attention of an individual after 1 year but causes serious harm would likely be allowed to proceed by the court. The bill also makes important allowance for those occasions where someone publishes a statement that has previously been published and there is a material difference between each. And that flexible approach we have taken is capable of taking into account a material difference between each subsequent publication. So, Deputy Presiding Officer, I move that the Parliament agrees to the general principles of the Defamation and Malicious Publication Scotland Bill.
Thank you. We now go to Adam Tompkins on behalf of the Justice Committee for up to 7 minutes, please. Mr Tompkins.
Thank you very much, Deputy Presiding Officer. In its report on the Defamation and Malicious Publication Bill published last month, the Justice Committee reached the unanimous conclusion that the Parliament should support the Bill's general principles. And I'd like to thank all of the witnesses who gave evidence to the committee. I'd like to thank the clerks and the Parliament's officials who give so much help to the committee on a daily basis. And I'd like to thank all the members of the committee for the thoughtful and measured way that they approached this bill. As we've just heard from the Minister, Presiding Officer, the bill originates in the work of the Scottish Law Commission, and it seeks to put the Scots law of defamation on a statutory footing fit for the 21st century. In doing so, it must address and balance two competing rights: freedom of expression on the one hand, and the right to protect one's reputation, which some see as an aspect of the right to privacy, on the other. Neither of these rights should be allowed lightly to give way to the other, and any law of defamation should strive to get the balance between them right. The committee believes that, taken as a whole, this bill achieves that aim. I do not think there should be any doubt, Presiding Officer, that it does so by shifting, albeit perhaps only subtly shifting, the balance that we have in the current law. The bill shifts the balance in favour of freedom of speech. It says, for example, that for a defamation action to succeed, a pursuer will have to show not merely harm, but serious harm to their reputation. And it says that defamation actions will have to be commenced within 1 year, rather than within the current 3-year period of the harm occurring. Some witnesses appearing before the Justice Committee were concerned about this shift in favour of greater freedom of speech, but most welcomed it. And in particular, and unsurprisingly, media organisations welcomed it strongly. It would address the chilling effect, they told us, which the current law of defamation can sometimes cast over journalists, publishers and writers when actions are brought, or indeed even threatened, by pursuers with deep pockets and thin skins, to use a phrase that was memorably cited in evidence. Raising the threshold for defamation actions from harm to serious harm is probably the most contentious change the bill makes. In doing so, the bill brings Scots law into line with a position already in force in England and Wales. And some of our witnesses, as the Minister referred to, wondered if this was not an English solution to an English problem. But others strongly disagreed, including Andrew Tickell, representing Scottish Pen, Nick McGowan-Lowe of the NUJ, and Peter Gagan, among others. In her response to the committee's report, for which I thank her, the Minister backs the new higher test of serious harm, and she cites the work of the Scottish Law Commission in doing so. And speaking for myself, if I may, I think she's right to do so. Indeed, the committee's view was that, on balance, it favoured retention of the serious harm test in the bill. I want to move, Presiding Officer, to two aspects of the bill where the committee does think that further work is required at stage 2 to ensure that the legislation is properly drafted to meet its objectives. The first of these is the so-called Derbyshire Principle. Named after an English case decided by the House of Lords in the early 1990s, this is the principle, as the Minister just said, that local authorities may not sue in defamation. If you are an elected official, the place where you seek to protect your reputation is at the ballot box, not in the defamation courts. And the bill seeks to put this principle, which is a judge-made rule of the common law, on a statutory footing. The committee welcomes this, but is concerned about the scope of the principle as it is currently drafted. In particular, the question is this: should private bodies that are carrying out functions of a public nature also be barred, as local authorities are, from suing in defamation? And if so, what about universities or housing associations? In her response to the committee's report, the Minister records that she is opposed to extending the Derbyshire Principle to all private bodies carrying out public functions. That is a commendably clear steer, but I suspect it is a matter that will be revisited in due course when the committee considers amendments to this bill at stage 2. The second area of concern highlighted by the committee relates to malicious publication. This is a separate delict from defamation, albeit that the two are closely related. And of course, this bill deals with them both. And because it's a separate delict, it has its own ingredients, which overlap with, but are not identical to those of defamation. On the one hand, for example, harm has to be caused, but not serious harm. On the other hand, however, to sue for malicious publication, the pursuer must show that they have suffered or are likely to suffer financial loss, whereas this is not always a requirement in defamation cases. There is one striking omission in the way the bill deals with malicious publication. It says nothing about defences. One of the most attractive aspects of this bill is the way it modernises defences in the law of defamation, sections 5, 6 and 7 of the bill. But in stark contrast, the bill is silent on defences in the law of malicious publication, and this needs to be rectified. And I raise it now because the Minister seemed to have overlooked the committee's view on this in her response to our report. She did refer to it in her remarks a few moments ago, but what I would gently say to her, I think, is that this is a matter which needs to be dealt with on the face of the bill and not in the explanatory notes accompanying the bill. But let me say that I'm very happy to work with the Minister and her officials on both of these issues, both on the scope of the Derbyshire Principle and on defences to malicious publication between now and stage 2, if the Minister would find that helpful. Let me close, Presiding Officer, with this final point. Throughout our deliberations, the committee was anxious that placing the modern law of defamation on a statutory footing should aid the accessibility of the law, but should in no sense freeze its ongoing development in the case law of the courts. The single most important and liberalising reform to defamation in recent years, the creation of the new defence of publication in the public interest, in the Reynolds case, came in case law and not statute. The committee welcomes this bill and supports its general principles, and it does so in the hope and in the expectation that it will assist the courts as the law of defamation and malicious publication continues to be developed by them, even after this bill is enacted. Thank you very much.
Excuse me. I now call Liam Kerr for 7 minutes, please.
Thank you, Presiding Officer. I remind the Chamber that I'm a practising solicitor holding certificates from both the Law Society of Scotland and England and Wales. It seems that large parts of my week at the moment are set aside for reading, questioning and commenting on freedom of speech, and rightly so, as this is one of our most important fundamental rights. And in these times when technological developments and social media have allowed pretty much anyone to be a creator or a publisher, it's imperative both that free speech is protected and any threats to it caused by laws are challenged. But it is also key to protect individual reputation and the right to privacy. And it is striking the balance between these two rights that this bill seeks to achieve. And the Scottish Conservatives consider that, in its principles, the Defamation and Malicious Publications Bill broadly achieves that balance and will vote in favour at decision time tonight. Several areas merit further consideration as the bill progresses. The convener has just now encapsulated my thoughts on the Derbyshire Principle in his comments, so I'll confine myself to 3 other areas: the serious harm test, malicious publication, and a brief comment on limitation. Now, in relation to serious harm, if passed, the right to bring defamation proceedings in respect of a defamatory statement will accrue only if publication has caused or is likely to cause serious harm to the subject's reputation. According to the policy memorandum, this test, referring back to the Scottish Law Commission's work, is required because of the lack of authority in Scots common law and the inability of Scottish courts to dispose of trivial claims at an early stage. Now, that I find interesting because if there's a lack of authority, then one wonders whether the Law Society have a point that an extra hurdle could deter legitimate claims, leading to even less such authority developing. And whilst ensuring the ability to dispose of trivial claims feels right to me, the Faculty of Advocates suggested that there is no reason to think that the Scottish courts have hitherto been troubled by such trivial claims. But that having been said, I listened very carefully to the media respondents in particular, who said that a serious harm test adds clarity, it prevents cases without merit going forward, and helps prevent a chilling effect in their investigations. I felt Dr. Tickell's evidence was particularly powerful, that this is not just journalists, this is writers, this is bloggers, this is anyone engaged in the public sphere asking, can I afford to defend myself? And the Society of Editors noted that the English reduction in the chilling effect benefits academics, scientists and others. And it's this final point which I found particularly persuasive. So whilst I see merit in both views, I feel the committee's report articulates the debate well, and on balance I align with the committee's view to favour retention of the serious harm test. But that internal dialogue informs my view that the committee was right to recommend the Scottish Government set out clearly why the serious harm test is still required. And I've read the Minister's letter of 29th of October and listened today, and I'm not sure that she's demonstrated a requirement. And I'd be interested in colleagues' views around the Chamber on that in the debate today, and I respectfully invite her to consider setting out why it is required before stage 2. Now, serious harm is notably absent from the sections on malicious publication. And I focused on this area during the committee sessions because I was concerned that this area might not have been such a priority in the bill's drafting. Even the policy memorandum says that the purpose of the bill is to, quote, simplify the law of defamation, brackets, and the related action of malicious publication, close brackets, in Scotland. And this almost afterthought nature of Part 2 has been explored by the committee, with concerns including that the bill arguably sets a very low threshold to show malicious publication, as what is required to show that a statement is malicious is knowledge or indifference that a statement was false. Thus, a pursuer can show malice merely by adducing indifference to the truth. Secondly, in the definition of malice, the pursuer must show that indifference or malicious intention, not and. And there's no concept of serious harm, only a degree of financial loss, which doesn't actually have to be caused, with no de minimis. There is a lack of clarity as to whether secondary publishers are immune from this part, and on which note, as articulated by the convener, there's no clarity over defences applying in this area. Now, the logical progression of such drafting, according to the likes of Professors Reid and Blackie, is that malicious publication might become a preferable action to defamation. And they suggest amending the definition to require falsehood and malicious intention, or at least reckless indifference to the truth. And Dr. Tickell was clear in his view that if one is persuaded by the need for a serious harm test at the outset, it would make sense to consider it for this part also. So I note the Minister's intention to amend, which I'm grateful for. And with regard to the defences, I note the convener's remarks, but also that the Minister's letter committing to look carefully at this if an amendment is lodged. I might encourage her, however, to look at it carefully as soon as possible on her own volition, however, and I do associate myself with the convener's remarks around the explanatory notes. Now, finally, a brief word on limitation, as this is another area of particularly interesting debate. The bill reduces limitation within which an action must be brought from 3 years to 1 year from first publication. Now, I understand the rationale, including that a longer limitation can discourage publishers' investigation. And I accept the argument that it is difficult to believe that nowadays someone wouldn't be aware of material which caused serious harm to their reputation within a year. But one can envisage a situation in which cumulative statements do serious harm in the aggregate, rather than at first publication of the initial statement. Now, the Minister argued in her remarks that there is an equitable discretion on the court to allow a claim through that was otherwise out of time. And she's right, of course. There is a general power to override time limits in the 1973 Prescription and Limitation Scotland Act. But it doesn't specifically refer to defamation actions in the same way as the English Limitation Act does. And therefore, I think there's at least an argument that we have a weaker protection in Scotland. And I feel that clarity would suggest that an amendment is worth exploring in this regard. And furthermore, Section 33 of the bill makes provision for a limitation interruption where there is mediation, which is helpful. However, one wonders whether this might be extended to take account of other forms of ADR, such as arbitration, expert determination, press complaints, or ombudsman bodies. So these are some areas where I think further reflection is needed. But at this stage, I confirm the Scottish Conservatives agree with the principles of the Defamation and Malicious Publications Bill and will vote for them at decision time tonight.
Call Rhoda Grant for 6 minutes, please.
Thank you, Presiding Officer. It's always been a balance that needs to be struck between freedom of speech and the rights of an individual not to be defamed. We need to make sure that the legislation strikes the right balance between both these rights. People must be held to account, especially when they are that is in the public interest. This is true of government and elected politicians. We're there to represent the public interest, and the public and media must be able to question and scrutinise our actions without fear of litigation. On the other hand, people should not face damaging and untrue accusations without recourse. When people's very livelihoods are at stake because of unjustified damage to their reputation, there must be a method of correcting the record. And as with everything, where there are rights, there are also responsibilities. Scottish Labour support the general principles of the bill and hope that where there are concerns, they will be dealt with as the bill proceeds. It's also worth pointing out that the bill comes from the Scottish Law Commission work, who reviewed the defamation law back in 2017, as the Minister pointed out. Scottish Law Commission do very valuable work in this area, consolidating and reforming law, and it's good to see some of that work coming through the Parliament. There have been several concerns expressed about how the bill translates case law into statutory law, concerns about the way in which case law has been interpreted, and concerns about the ability for the law to be refined over time by case law when it is codified. This evolution is required because of the way in which we communicate changes with time. 20 years ago, social media was almost unheard of. Now people use that to follow the news and gain information. And we are all publishers, but some of us are not very great editors. We cannot at this moment of time foresee how methods of communication will change, whether this bill we are considering today will be fit for purpose in, say, 10 years' time. We always need to allow case law to develop, how the law is interpreted in order to follow changes in the way in which we communicate. The bill is very technical in that it's trying to codify a case law, which means that definitions in the bill must capture the nuance of case law. And this occurs in several places throughout the bill, but critically in the definition of defamation itself. And that was a subject of concern, some believing that there was no need for a definition as case law provided guidance that was widely understood. There were also concerns that defining defamation in legislation at all would prevent case law developing the definition in future. The committee came down on the side of a statutory definition, but also wanted to ensure that that definition could also be codified in the future by case law. And I'm not sure if that's possible, but I understand the Minister is going to look at how that can be achieved. There are also concerns about language and the translation of case law into common law, into statutory law in other parts of the bill. For example, as has been mentioned, the Derbyshire Principle. In England and Wales, public bodies are prevented from bringing defamation claims under the rule known as the Derbyshire Principle. The bill creates a statutory version of this rule, but includes the exemption for charities and business when they deliver public services from time to time. And there has been concern about the impact of this, and the committee recommended that clarity is needed in the bill on the application of this principle and exception. Scottish Labour supports the Derbyshire Principle that public bodies and agencies should not be permitted to sue for defamation in relation to public activities, and believe the bill needs to clarify how this principle extends to private contractors involved in public service delivery. These issues need to be dealt with to ensure there's no unintended consequences due to the modernising of the law. The Minister has indicated to the committee that she'll look at these issues with regard to translating case law into statutory law, and they must strike the right balance. The bill introduces the serious harm test and is similar, but not the same to that that's included in the 2013 Act for England and Wales. And this is one of the more controversial changes to the existing law. It is welcomed by some as a method of preventing vexatious cases or litigation threats from those with sufficient resources. The committee hears that this can have a chilling effect on important media scrutiny and freedom of speech, meaning that the threat of being sued can have the effect that information which is in the public interest to publicise is being suppressed. A number of defences are also placed on a statutory footing, and the new defence of being in the public interest is created. This hopefully will ensure that those with deep pockets can simply suppress information from being shared with the public when that's in their interest to know. This is a common law defence that exists in England and Wales. The law surrounding malicious publication is also clarified, and as we've heard, there are some concerns about that, in that it would allow a loophole for those who wish to bypass the public interest defences. There are also concerns that the bar is set too low. Professor Blackie said that he interpreted the bill as defining malice as requiring knowledge that a statement was false or indifferent to the truth, or the motivation by malicious intention to cause a loss. Currently, he believes that the law requires a definition of malice to have the design to injure, and he suggested that the definition be amended to require knowledge of a falsehood and malice, and I'm glad to hear that the Minister's looking at this. This bill is welcome. However, given the sensitivities of the issue, it's important to get it right, and therefore I'm heartened that the Minister appears to have heard those concerns and is willing to listen to the committee and amend the bill accordingly, and we will support that process.
I call John Finney, please, for 3 minutes.
Thank you very much indeed, Presiding Officer. Can I also commend the work of the Scottish Law Commission, who provide the foundation to this bill, and thank all those who provided evidence briefing, and indeed the staff who have helped us throughout. This legislation covers an important part of civil justice, defamation. And as has been said previously, the Justice Committee focused on two important competing elements required to be considered in this legislation. That was freedom of expression, something we're hearing a lot about, not just in the committee in relation to this, but also other legislation that's ongoing, and protection of reputation. And the question as to whether the appropriate balance has been reached, well, firstly, can I say I agree with the convener that the shift does favour freedom of speech, but broadly speaking, the committee consider the bill strikes the correct balance, subject to comments and serious harm, which my colleague Andy Whiteman is going to touch on. The Scottish Government say that defamation law should be as clear as possible and as accessible as possible. And I think there's an argument made that putting it on a statute footing brings some clarity, but accessibility, it's been referred to in correspondence as mythical, and perhaps not exclusive to this particular piece of legislation. Access to justice is important. The term ordinary persons is also mentioned, but I have to say I remain to be persuaded that this is a piece of legislation that will be accessible to ordinary people. I concentrated my scrutiny mainly on the Derbyshire Principle, which has been touched on there. And it's important to say that the Lord Law's decision that gives rise to that principle said that public bodies should be open to uninhibited public criticism, that reputation should be protected by political rather than legal means. There's a statutory version of that which exempts, talks about businesses parties who are exempt from time to time, but the principle that has to be followed here, and the convener accurately reflected the content of our Stage 1 report, which I'm a signatory to, but certainly it's the case that I would go beyond many members on this, because we must have effective scrutiny of outsourced public services. If I give you an example, my constituents in the Western Isles clearly have more freedom to talk about the quality of their ferry service provided with the public service, rather than my constituents in the Northern Isles whose service is provided by Serco, whose own website tell us they do health, transport, justice, immigration, defence, etc., etc. And only yesterday were the subject of public criticism about a prison officer in one of the private prisons in England being required to clean a cell without appropriate equipment. So there is a balance to be struck. The most important balance with all legislation is that it's right rather than might that applies. So I think there's a way to go with this yet, but at decision time tonight, the Scottish Green Party will be supporting the general principles of this bill. Thank you.
Thank you very much, Mr Finney. And I call Liam MacArthur. 4 minutes, Mr MacArthur.
Thank you, Deputy Presiding Officer, and can I too thank all those who gave evidence to the Justice Committee, our clerk, Spice and others who've helped in our scrutiny to date, and of course the Scottish Law Commission, whose work laid the foundations for this bill. And the Law Society point out that modernising and codifying the law of defamation is overdue and should help enhance accessibility. At the same time, as others have said, achieving a proper balance between protecting reputation on the one hand and freedom of speech on the other is not easy, though obviously absolutely essential. In the main, I believe the Defamation and Malicious Publication Bill achieves that balance, albeit further changes will be needed at stages 2 and 3. Broadly speaking, that reflects, I think, what the committee heard in evidence, though important concerns were raised, particularly by the faculty who feel the bill goes too far in trying to address a problem they feel doesn't really exist in Scotland. Duncan Hamilton talked, as the Minister said, of English solutions to an English problem. By contrast, Scottish Pen and media witnesses felt the scales could safely be tipped a little further, highlighting what they see as the chilling effect of those with, quote, thin skins and thick wallets being able to silence fair comment through threats of legal action. Reference was made to the more precarious media environment where savage budgets and high levels of freelancing mean the risk of even pursuing, far less publishing certain stories was one that editors, journalists and publishers were increasingly wary of taking. Overall, however, the committee generally satisfied the bill is pitched about right, a view I very much share. I welcome, as did witnesses, the inclusion of a statutory definition of defamation, though as in other areas like defences, there is a concern, as the convener said, to ensure flexibility, to allow adaptation over time and the ability to draw on case law. The Minister has expressed sympathy with that, but it may still require amendment to the bill. Perhaps the key area where debate over competing rights and freedoms emerged was in relation to thresholds, specifically the inclusion of a serious harm test. The Minister defends this change, suggesting, quote, the current law simply presumes that damage has been done. I'm not sure that's true. Damage still needs to be proven, with any award contingent upon the seriousness of the harm caused. I confess, having been a firm supporter of the serious harm threshold initially, I do now have some misgivings. The committee didn't really form a clear view on this question, but it's one we will need to return to and resolve at stage 2, and I look forward to hearing what Andy Whiteman has to say later in this debate. Meanwhile, more clarity is needed around both the way in which the Derbyshire Principle is expressed in the bill and also the codification of defences. The Minister seems reluctant to concede on either point, but while I support the direction of travel in both areas, I think it's regrettable the Minister hasn't responded more positively to the clear concerns that were raised with the committee. Similarly, in relation to the welcome exclusion of secondary publishers from liability, the Minister appears unwilling to accept that anything more needs to be done to help those who may wish to request the removal of material. She refers to simple procedure rules in the Sheriff Court and £19 actions. This picture was not necessarily reflected in the evidence we heard. Whether it needs addressing on the face of the bill or through other means, I do think that this merits further attention. Finally, on the question of limitation, again, I welcome the reduction to 1 year for bringing a case. In a digital age, this does not seem an unreasonable timeframe and can help address some of the chilling the committee heard about. That said, there may still be legitimate reasons why such a timeframe could prove problematic, whether due to a genuine lack of awareness about material or possibly due to the cumulative impact of repeated references. The Minister insists allowances are made within the general law of limitation, but again, we need to return to this at stage 2. Deputy Presiding Officer, as I say, in the main, I believe this bill broadly achieves an appropriate balance between rights of protecting reputation and freedom of expression. It's also encouraging to hear the work being done to promote greater use of mediation and other forms of dispute resolution. I look forward to continue working with committee colleagues and the Minister to improve the bill where necessary. But for now, I can confirm that Scottish Liberal Democrats will be supporting the general principles this evening. Thank you.
Thank you very much, Mr MacArthur. I see I've got quite a few remote speakers. I've been thinking about how to let you know that you've got a minute to go, and I've got another thing in my repertoire, so we can try it out on a Thursday afternoon. I'll tap my microphone when you've got 1 minute to go. Can you hear this? That's what I'll be doing then. Thank you very much. So I just thought we'd try it for a change. So we're all in an equal status. So people here, people that are working remotely, don't get any longer just because they can't tell the time. I don't know what signals the Minister's giving to me, but I'm ignoring them. I'll call it Rona Mackay, followed by Gordon Lyndhurst.
Thank you, Presiding Officer. I'm pleased to be able to speak in today's Defamation and Malicious Publication Scotland Bill at Stage 1, and will be happy to pass the general principles today at decision time. Presiding Officer, it's generally accepted that the existing law of defamation in Scotland is piecemeal and out of date. Put simply, the current defamation law in Scotland is no longer fit for modern day purposes. The last substantive change to the law in Scotland was made 24 years ago. So this bill aims to clarify and strengthen the statutory underpinning of defamation in Scots law in order to protect freedom of expression and protect an individual's reputation. In fact, those considerations are at the heart of this bill, encouraging access to justice for those who believe they've been defamed by clarifying the law and protecting freedom of expression. It is a technical bill consisting of no less than 40 sections in 3 parts and 1 schedule. So as Deputy Convener of the Justice Committee, can I put on record my thanks to the clerks and the bill team for all their hard work in setting it out for us in a comprehensive and logical way. Presiding Officer, at the outset of this bill, I have to confess that I had a preconceived notion that it would be dry and intensely legalistic, but I was wrong. I think I speak for everyone on the committee when I say that the many witnesses from a legal, media or creative background gave evidence in a way which made each session fascinating, informative and real, and I thank them for that. So the bill places certain key elements of Scots common law and defamation on a statutory basis, in addition to replacing and restating elements of the existing statutory provisions in Scots law. It's impossible to cover all aspects in a short speech, but I'll try to cover some of them. Part 1 provides a new definition of defamation and introduces a threshold of serious harm, possibly the most contentious element of the bill, which I will outline a bit further on. Part 1 also covers defamation actions relating to public authorities and business interests. Part 2 makes a number of provisions to replace common law verbal injuries with 3 new statutory clauses relating to malicious publication. Part 3 seeks to reduce the time period for bringing a defamation act from 3 years to 1 year and introduces the rule that the clock starts running from the first occasion a statement is published. I believe this is a sensible clause, as in most cases a person would know almost immediately when they believe they have been defamed. However, it doesn't take into account the accumulative straw that breaks the camel back effect of being defamed over a period of time, which did come up during evidence sessions. So I'm pleased that the flexibility could be used here on a case-by-case basis. Presiding Officer, a lot of discussion and evidence involved the so-called chilling effect. Media organisations argue that defamation law in both Scotland and England was having what's termed a chilling effect on freedom of expression. The argument is that those who can afford it can use the threat of legal action to quash stories and silence criticism, often by way of legal warning letters. The law on defamation is uncertain and relies heavily on decisions in previous cases. This makes it difficult to judge the prospects of success. The defenders may simply be too scared to meet the significant costs of court action. The National Union of Journalists has highlighted that traditional media organisations are struggling to maintain their financial viability and may simply drop a story. And that is the chilling effect. In addition, today's freelance culture means many more journalists don't have the backing of a major news organisation. Presiding Officer, as I said earlier, the threshold test of serious harm was a divisive issue during evidence sessions. As the Minister said, some opinion referred to as an English solution to an English problem. However, the Scottish Law Commission firmly believes, as does the Scottish Government, that it would achieve the balance between freedom of expression and protection of reputation. It would discourage frivolous action and reduce time and money for the individual in civil courts. If a person says their reputation has been unfairly damaged by a defamatory statement, then surely it's only right that they should show how it has been damaged. Presiding Officer, the digital revolution in online publishing and social media during the last 25 years...
I'm sorry, Ms Mackay. I've rattled and banged my little microphone here to no avail. You're running. Could you just conclude?
Oh,
yeah,
sorry,
yes, oh.
Officer, yes,
What did you think I was doing?
That experiment didn't work. Presiding Officer, in conclusion, the Minister has listened to the evidence the committee has heard and has committed to consider and act on our recommendations in most cases. This is our opportunity to make the law of defamation fit for purpose, and I'll be pleased to pass the general principles at decision time. Thank you.
Thank you. I'm just being told you couldn't hear that over Blue Jeans, but you indicated you could, Ms McKenna. You couldn't hear it. Well, I'll need to try something else. I don't know. Well, I'll let that experiment die a quiet death. Call Gordon Lyndhurst, we followed by Annabel Ewing. Mr Lyndhurst, please.
Deputy Presiding Officer, do not spread false reports. Is that statement something new? No. It is just the current translation from the Hebrew of Moses' words in Exodus 23, verse 1. And it chimes with the right to freedom of expression in both public and private, which is the heart of Western democracy, if not the heart of Western democracy. Because individuals must be entitled to protection from provable untruths. In other words, and forgive me for using the word in this place, but it is apposite, lies, slander, and malicious publications which would materially affect livelihoods and reputation. It is a pillar of any system which is based on the rule of law that truth should triumph over fiction, and in particular triumph over deliberate or malicious fiction deliberately directed against individuals. Veritas vincit, pronounced vincit or vincit, depending whether one believes the ancient Romans, which this is hardly credible, pronounced their C's as soft C's or not. Therefore, I generally welcome this bill, which should clarify several matters. The common law action of verbal injury, given a new statutory basis for malicious publication. However, who knows how the serious harm threshold test, which the bill sets out, will develop. And I note with interest the submission from the Faculty of Advocates, which has raised questions about the secondary publication rules in the proposed legislation and the regulation of internet publication. Indeed, clarity is needed on this issue. Now, we must all deal with, and the law itself must at least establish a sensible framework to deal with, ever-changing methods of information distribution on social media and the internet. Such things were obviously not regulated by even recent statutory or common law prior to this century, far less in ancient Rome of Pliny the Elder's time. But the basic principles, as I referred to at the outset of my speech, abide. And our law, which implements those principles, must be kept up to date, relevant, applicable, and accessible. Whether the threshold test has been set too high for the bringing of claims, as some in the legal profession say, must be addressed at stage 2. But there should always be at least the criterion that a claim be of ostensible merit and worthy of the court's time. In other words, a statable case. Rigorous scrutiny is therefore what is required of this bill at stage 2. So I close with the question, is this Parliament up to the task? We shall see.
Thank you very much. I now call Annabel Ewing to be followed by James Kelly. Ms Ewing, please.
Thank you, Presiding Officer. And I must apologise, I lost connectivity for about 10 minutes at the beginning, so I missed part of the Minister's and part of the convener's comments. I should also refer members to my entry in the Register of Interest, wherein they will see that I am a member of the Law Society of Scotland, that I hold a practising certificate, current practising certificate, albeit I'm not currently practising. In the time available, which has gone from 6 to 4 in the flash of a second, I would just make a few comments. First, the definition issue. So the definition as proposed for the first time in statute in Scotland, as far as defamation is concerned, that it would involve circumstances where a statement is deemed to be defamatory if it causes harm to a person's reputation. And although the Scottish Law Commission did not, in fact, propose an express definition, the government felt, I understand on grounds of improving clarity, that this would be helpful. And indeed, I think that's the balance of the evidence that we have received in the committee, and I would, in fact, agree with that. The other issue I would address briefly is the serious harm test. We've heard a lot about that already this afternoon, and this, in effect, would make it a requirement to aver not simply that one's reputation had been harmed, but rather the harm must be at the level of serious harm. And if that cannot be established, a pursuer will not be permitted to proceed with their civil action. So this has indeed caused controversy, and we have heard about Duncan Hamilton's concern, Duncan Hamilton, the Faculty of Advocates, that, and I quote, what we are dealing with here is an English solution to an English problem, and in that he was referring to the problem of unmeritorious or frivolous claims having been brought forward south of the border, a problem that he said had not been the case in Scotland. And Mr Campbell-Dean, a practising defamation solicitor, was of the view, and I quote, by introducing that extra barrier, you would be putting a hurdle in the way of a litigant who may well have a perfectly good right of action. And Dr Scott of the London School of Economics felt that the introduction of such a test would add to the complexity of the law, with possibly a substantive hearing having to be held with significant evidence requiring to be led to determine whether the threshold had been met, adding to cost and complexity. So I think we can see that certainly as far as the legal profession and some academics are concerned, they have certain concerns here. Of course, it's fair to say that in terms of the press, media organisations, writers in general, and other academics, they felt that this was reasonable in the context of this issue of the striking of the right balance as between the competing interests of freedom of expression and the right to protection of privacy. I personally feel that, and I do think that the Law Society's helpful briefing on this issue this week should be reflected upon. I do feel this issue would merit further reflection, because I think it was John Finney who said we should be dealing with right rather than might. But it is important to remember in these debates, and important debates with the media, that not all people who allege that they have been defamed are the big guys. Some are the small guys. And surely we as a parliament are here to protect the small guys very much. And so I would urge a bit of reflection on this issue. The Law Society have suggested that we could look at perhaps finding language to the effect that we could seek to exclude vexatious actions to the extent that this provision apparently is designed to deal with this problem in Scotland. And of course, then there are procedural issues in terms of at what point and by way of what procedure, but presumably that would be easier to iron out. So I would just close with that, Presiding Officer. We need to protect the wee guys as well. And I think a wee bit of further reflection, keeping the spirit of what the Minister and the officials are trying to do here, but nonetheless just ensuring that we get this right, such that people have the ability to protect their rights, because I think it was Duncan Hamilton as well who said that one person's chilling effect is another person's right to actually assert their rights in society. So I think this would merit a further look at. Thank you, Presiding Officer. I have no idea what time it is now.
No, I've given up. Not really. I call James. I don't think I have. I call James Kelly to be followed by Fulton McGregor, please.
Thank you, Deputy Presiding Officer. This is actually the first time that I've spoken virtually in a speech to the Scottish Parliament, so you'll be glad to know that I've set my stopwatch running so as not to fall foul of the Deputy Presiding Officer's time restrictions. I want to support the general principles of the bill, and as a member of the Justice Committee, thank the clerks and all those who gave evidence to a bill which covered a number of extensive areas. I think, as other speakers have said, it's important in this bill to ensure there's a correct balance between protecting freedom of speech, but also ensuring that those who are unfairly and sometimes viciously defamed have protections in place in order to take corrective action. A number of issues that have been touched on in the committee evidence and also in today's debate. There's been quite a bit of discussion around the Derbyshire Principle, and I would agree with other speakers in that we need sort of further clarity around the definitions there, particularly around what is actually covered by a public authority, and also just this issue of those private organisations who carry out partial work in the public domain, how they are covered in terms of this legislation. I think in terms of the defences that have been set out in the bill, I welcome that work that has been set out to ensure that there are appropriate defences codified, so that, for example, those who are expressing an honest opinion or acting in the public interest have some appropriate coverage. I think there needs to be just some further work in terms of the offer to amends procedure where there are disputes, and in an attempt to avoid those disputes officially coming to court, a settlement is reached. Previously, there's been recognition where the defender makes some kind of apology, there would be a deduction, and there's been some confusion as to whether that's still in place or not. I think that needs to be clarified. I think a couple of other issues that are worth touching on. I think the Law Society briefing covered the issue of internet publication, and that's not something that's not been specifically covered by the bill, and I think they made a good suggestion that it would be useful for the law commissions across the UK to do some work in this area. The substantial growth in the internet and social media and the platform that unfortunately that can provide for people being defamed, I think is an area that's worth further investigation and may need further legislation. I think another area that's worth highlighting is that of access to justice. Could be the case that people are being unfairly defamed, but they don't have access to the resources or legal aid in order to be able to take a kind of proper court action. And similarly, the committee heard evidence that there's been a growth in online journalists, people writing their own publications online, and they may come into the scope of being involved in cases here but don't have appropriate access to legal aid. So I think that's worth revising. So I think this is a bill that's welcomed and certainly be supporting the general principles at decision time. Thank you, Deputy Presiding Officer.
Thank you very much, Mr Kelly. And I think I'm told some members were unaware it's 4-minute speeches, which I thought everyone knew, but it's 4-minute speeches unless you're summing up. Fulton McGregor to be followed by Graham Simpson.
Thank you, Presiding Officer. And as a member of the Justice Committee that has taken this bill through stage 1, I want to put on record my thanks to colleagues and particularly the clerks. It's been a complex and at times technical bill, and while not always headline grabbing, it's nonetheless important and one that is needed in the 21st century. As others have pointed out, freedom of expression remains important. However, we must also consider that what safeguards we can put in place to ensure an individual's reputation is not unjustly tarnished. We have ascertained that the Scots law definition of defamation and verbal injury is no longer fit for purpose. It isn't concise, doesn't strike the right balance, and importantly, it simply isn't modern enough to deal with issues such as online publications. By introducing this bill, we will be able to improve the accessibility of the current common law, making it more straightforward for individuals to use, and we will crucially ensure the relationship between freedom of expression and individual reputation is considered with balance. It will also raise the threshold for bringing defamation actions, various proposals, including the serious harm test, a single publication rule and a 1-year time limit to raising court action. It will, in effect, create a higher threshold for taking court action, ultimately helping to balance the law protecting freedom of expression. Because in truth, Presiding Officer, the law of defamation has been amended in a disjointed fashion, with the most recent legislative changes occurring in 2013 and before that in 1996. And with the commonplace of online publications, the world is now very different, and we must make sure that the law reflects that. It isn't just publications that are affected now because of this aspect. Social media and messaging apps, for example, have opened up a whole new world. Any individual in this room with access to a smartphone can become a content creator with the click of a few buttons. And most of us here have some kind of social media account, and we can voice our opinions and views on any given subject within seconds. And while to encourage social media use responsibly, we don't have the safeguards in place that can be seen in print media. However, that is why we must update our current legislation. It is not fit, as I say, for purpose and for a world that goes beyond print publications. And the new bill would make provision for the courts to require a website to remove content and to require other people or bodies to stop distributing or showing material. The main issue that the bill is designed to address are the chilling effect on freedom of speech of the current law. And we're in a situation where people will feel they cannot publish something for a fear of legal action, made worse by the complexity of this law in its current state. And this can add costs of defending court proceedings, and so publishers can feel silenced because there may be consequences for publications that mention an individual. This bill will in effect clarify that cases can only be brought forward where real harm has been done to an individual's reputation. And I noticed I note the Minister's point in terms of the serious harm threshold, which was one of the most widely discussed issues that the committee took during the evidence session. Some of the other issues that we looked into, Presiding Officer, which I know have been covered by other members, and that's mainly because there only was a few areas where there was contention, if you like, was, as others have talked about, the Derbyshire Principle, and I think it's fair to say that, for the record, that my colleague John Finney actually undertook the legwork on this at committee at stage 1. As has been said already, we recommended in our report that the section is redrafted, so the Scottish Government's intention is clearer and that clarity is provided as to which bodies are covered, as well as providing examples of those which are exempt. And I fully welcome the Minister's offer to work with members to ensure that we get a provision that codifies the Derbyshire Principle as it exists at the moment, and one that would alleviate concerns of the stakeholders and be clear and as flexible as possible. We've heard also about secondary publishers and malicious publication. Presiding Officer, I can see that my 4 minutes is up, but I wanted to say that I think that the Minister's approach throughout has been one of willing to work with the committee getting into stage 2, and that's also reflective of our overall approach to the previous bill that she brought forward to the Justice Committee as well. And I look forward to taking through to stage 2, and I promote the principles at this stage. Thank you, Presiding Officer.
Thank you. I now call Graham Simpson, followed by Shona Robertson.
Thank you. I come to this debate as someone who used to have to think very carefully about defamation on a daily basis. As a newspaper reporter and then a sub-editor on local newspapers and latterly for the Scottish Sun, I had to have some knowledge of the law in this area, both in England, where I first worked, and then in Scotland. And although at the Sun we had lawyers who came in every night, you had to make judgment calls quite a lot on how to phrase things. None of my employers were ever sued over anything I wrote, though there were 1 or 2 apologies over the years. That goes with the territory. So it was with great interest that I read the bill, the committee's report, and the Law Commission's report too. So having worked in newspapers, I have that perspective, but now in politics, I have to be careful of what I say through other mediums. It's all too easy to tarnish someone's reputation on social media, online, and for that to be done multiple times by multiple people. I've also learned that as a politician, the threshold of what people can say about you is different from others. In essence, you have to be able to take some flack, whether it's true, fair, or not. Overall, I think the bill is sensible, and I'm happy to back it at this stage. Firstly, the bill will mean that, for example, were I to email Gordon Lyndhurst with some defamatory remarks about him, he could not sue me. But were I to have foolishly copied in Liam Kerr, then I would be in trouble. And bizarrely, this is not the case at the moment. So I agree with that reform. At the heart of the issue is the need to balance the right to freedom of expression and the freedom of the press and the protection of reputation. Then there's the so-called chilling effect, whereby media outlets will not publish for just the fear of being sued. And I've seen that many times, where accurate stories are either not run or are toned down heavily, much to the annoyance of writers. And the NUJ mentioned this in evidence. This benefits those with deep pockets. The bill sets a useful threshold. The Law Commission recommended it should be competent to bring defamation proceedings in respect of a statement only where the publication of the statement has caused or is likely to cause serious harm to the reputation of the person who's the subject of the statement. That's entirely sensible, and I think that should cut out frivolous claims. Section 2 places on a statutory footing the principle laid down by the case of Derbyshire County Council versus Times Newspapers Limited, that a public authority has no right at common law to bring proceedings for defamation. Quite right too. The presumption against a jury trial in defamation actions is, I think, a good idea. As the Newspaper Society said, it's long been the view of news organisations that there is an inherent bias against journalists, especially when it comes to trials involving prominent individuals, and judicial direction to set aside preconceptions is often not sufficient to even this out. The change in the limitation period from 3 years to 1 is also welcome. Finally, there are various bits of the bill which deal with defences, and these appear to be sensible. The committee points out parts which can be tidied up, and you'd expect that, but it can be sorted out by the fine minds of those on the Justice Committee, and that's not defamatory.
Thank you very much, Mr Simpson. I call Shirley Robertson to follow by Andy Whiteman.
Thank you, Deputy Presiding Officer. I'm very pleased to speak in this debate and support the general principles of the bill. This is a very positive Stage 1 report from the Justice Committee, which makes a number of recommendations. And like others, I'd like to thank the Scottish Law Commission along with the clerks who have worked hard to get us to this stage. I also welcome the Minister's positive response to the report and the commitment to reflect on the committee recommendations further. In essence, at the heart of the bill is an attempt to strike a balance of protection of reputation and freedom of expression. The committee recognises the strength of feeling behind the views expressed both to support freedom of expression and in relation to the importance of protecting individual reputations, and agrees with the Scottish Government's view that the bill represents a package of measures creating an overall balance and makes no single overarching recommendation to fundamentally alter the overall balance of the bill. I want to focus the rest of my remarks on a couple of specific areas. The inclusion of a serious harm test was one of the main provisions where the evidence was divided between those that welcomed it and those that regarded it as a step too far in limiting a pursuer's right to protect reputation. For some, the serious harm test is a necessary threshold which will ensure that only relevant cases where serious harm may have been done to someone's reputation go ahead, and that frivolous or vexatious cases are discouraged. In the view of some of our witnesses, the serious harm threshold would give people who were subject to threats and menaces of defamation action greater security. The so-called chilling effect was a concern for many media organisations, with reference made to those with deep pockets and thin skins, and they expressed strong support for the serious harm test. The committee also heard evidence to the contrary, that this level of threshold is tilting the balance too far away from the rights of an individual to protect their reputation, and that by introducing an extra barrier, you would be putting a hurdle in the way of a litigant who may well have a perfectly good right to protect their reputation and take matters further. I recognise that both views have merit, and on balance at this stage, in the light of the overall set of provisions set out in the bill, I think it's right to retain the serious harm test in the bill, although I agree with colleagues that it would be helpful for the Minister to set out a clear statement on why the serious harm test is required. There were concerns expressed by some witnesses that changes to the time limit for bringing defamation action may operate unfairly in some circumstances, and in particular where it takes time to find out that a defamatory statement has been made and where the effects of that statement are cumulative over a period of time. But the evidence from the Minister is helpful in setting out that the courts have discretion in certain circumstances to allow cases out with a time limit to proceed, and I think that's welcome. During evidence taking, the committee received helpful views on how access to justice in the area of defamation can be improved. These include looking at the provision of legal aid in this area and whether some form of pre-action protocol could be put in place. It also recommends that an accessible guide to the law in this area is produced, something I strongly support. And I'm pleased to see that the Minister in her response has said that she has sympathy with that and can see value of having a protocol in place, especially in ensuring that preliminary matters can be dealt with, and has said that she'll write the Scottish Civil Justice Council for them to consider this, which I think is a welcome step. So, Deputy Presiding Officer, I'm pleased to support the general principles of this bill.
Thank you very much, Ms Robertson. I call Andy Whiteman to be followed by Stuart Stevenson, and Mr Stevenson is the last speaker in the open debate. Mr Whiteman, please.
Thanks, Presiding Officer. I want to focus my remarks on the serious harm threshold because it's a significant change. It exists, of course, in England and Wales in Section 1(1), which states that a statement is not defamatory unless its publication has caused or is likely to cause serious harm to the reputation of the claimant. The bill before us, by stark contrast, does not follow that straightforward formulation, but instead defines a statement as defamatory if it causes harm, but then in addition states that for it to be actionable, that harm must be serious. And so in that respect, I disagree with Adam Tompkins that Scots law is being brought into line with England and Wales, and I'll return to that. Now, following the Supreme Court ruling in Lachaud, liability in defamation cannot be established by reference to the inherent tendency of the words alone, but has to have regard to the facts and the circumstances. And thus, the court will need to hear evidence on whether the alleged words written or spoken were indeed ever written or spoken, whether they bear the meaning alleged by the pursuer, and the reasons why, if defamatory, serious harm is or is likely to be caused. And that does require an evidential hearing. And thus there will need to be significant procedural rule changes to Scottish civil procedure to accommodate any pre-proof evidential hearing. I have 4 arguments against the serious harm test. First, as a matter of principle, we should not be shutting down civil law remedies for people without good reason. Someone, for example, who is defamed but only suffers harm is now to be denied redress, as is someone who suffers repeated harms over perhaps a long period of time, but where the threshold may never be met by any one instance. Secondly, as a caution to those who think this may act as some kind of procedural hurdle, as I said earlier, this will involve an evidential hearing and associated expense. In my recent £750,000 action, I would still have been in court for 6 days trying to thrash out whether in fact serious harm had ever been caused to the pursuer. Thirdly, a serious harm threshold will not deter a litigant determined to damage someone. That's what happened with me. It took a full proof, as I say, to conclude that no harm at all had been caused and no financial loss had accrued to the pursuer. And finally, fourthly, but very important, let us ponder what Parliament's being invited to do. Because Section 1(4)(a) states that a statement about a person is defamatory if it causes harm to the reputation, as I said earlier. And incidentally, this was not in the Scottish Law Commission Bill, and the Scottish Government has never published an analysis of responses it got to its own consultation. But any such statement is only actionable if the serious harm is serious. Presiding Officer, we're defining a civil wrong in statute, then saying there's nothing you can do about it. We're now seeking to deny civil justice to our constituents whose reputation has been harmed. Is this even compatible with Article 6 of ECHR? Presiding Officer, the threshold does little for defenders as full proof will still be required. The threshold, on the other hand, does a lot for pursuers, but in a wholly negative way and without justification. The bill risks denying legitimate pursuers their human right to a civil remedy for a wrong that we are defining as harm, but about which they can do nothing unless they can prove it is serious. Why?
Thank you, Mr Whiteman. I call Stuart Stevenson.
We live in a society built on free speech, built on the exchange of ideas and information. But by the same token, we live in a society where there are increasing levels of harmful false information. In addition to this, people around the world can express their thoughts on a scale unparalleled in previous human history. There are more and more platforms that people can use to publish their thoughts. Views expressed are almost instantly subject to the court of public opinion. A random thought can be seen by millions of people in almost no more than an instant. And the mechanisms for expressing our observations and critiques continue to grow. In stating this, I hope I've conveyed this specifically, that the world of communication continues to become more complex and more diverse, and that carries with it significant challenges. I believe there are 2 important principles we should adhere to. The first is simplicity, the second, balance. Now, the general public will not generally read legislation, but when they do, they should be able to understand it. This bill encourages both simplicity and balance. One way in which it encourages simplicity is the increased clarity of the situation. The ambiguity in our current legislation and case law can further complicate an already complex landscape. By clearly stating that any statement must be communicated to a third party and cause serious harm to someone's reputation, we reduce the burden of interpretation on all parties. I don't bring Mr. Whiteman's personal experience to the chamber when I say that, but I think while I'll read his words carefully, I probably disagree with them. In the ever-evolving global communications landscape, all of this is essential. Moving needless complexity ensures that energy and resources are focused on the elements that cannot be pared down so easily. Furthermore, I'd like to highlight the importance of improving the defence for secondary publishers. I published my first website 27 years ago, so I bear particular interest in this. Platforms and the way information travels has changed drastically, including over that 20 plus years since I got engaged with them. And far less of us on this planet 30 years ago had access to powerful tools. You had to own a newspaper to be able to have the kind of power that is at the fingertips of almost everyone today. But our understanding of how to engage with these new platforms has moved on more slowly than the evolution of the platforms themselves. But it's an improvement in defence for secondary publishers. And that provides clarity, and it places responsibility on those who actually write the words, those with creative control. And that's where it should lie. In relation to balance, the bill also makes an important movement towards free speech. It specifically does this through the single publication rule and the one-year limit. These together ensure that people do not have to fear legal consequences for statements that did no significant harm at the time of publishing, but might be less well received in a future context. We need to protect us all for honest social discourse. The bill tips the balance towards free speech in an important way. I therefore suggest the bill is a positive evolution towards how defamation and malicious publication are dealt with. The one thing the bill does not do is place inhibition on anybody criticising politicians. It's been said that the reputation of a politician cannot be damaged because they have none to lose. We can raise ourselves off the floor by this bill, perhaps, presiding officer. Thank you.
Thank you very much, Mr Stevenson. And closing speeches, I call Rhoda Grant, Cruz for Labour. 5 minutes, please, Ms Grant.
Thank you, presiding officer. This bill seeks to protect freedom of speech and also to protect people from harm. And today we've heard arguments about where the balance needs to fall between that freedom and that protection. The bill sets a higher bar in that defamation needs to cause serious harm, and that means people can't sue spuriously. Annabel Ewing talked about it being harm, not just harm, but serious harm, and the difficulty of proving that, and talked about how the legal profession have expressed concern. Andy Whiteman used his own personal experience to talk about the bar that would be set that may be too high for many people to reach. And he also talked about human rights legislation, and I think that needs to be looked at very carefully, because we need to make sure that people have access to justice when they require it. On the other hand, people talked about the chilling effect that the law as it stands has, and the threat to sue. The phrase deep pockets and thin skins was made by a number of speakers through the debate. So there is a balance to be struck as where that is struck. And as I said in my opening speech, with rights come responsibilities, and we need to make sure that both are in place. James Kelly talked about, in his contribution, about the law being just one part of the justice system. Access to it is another. The access to legal aid to make sure that people can access that to have recourse through the courts to protect themselves is really important, and a point made by the committee in its report as well. Liam Kerr talked about mediation and how welcome that was, getting people together to try and reach an agreement, and that the limitations within the bill were paused to allow that to happen. James Kelly talked about apologies and a retraction that happens currently, but maybe that is missing from the bill, and there needs to be a degree of clarity that encourages this action to be taken. Graham Simpson talked in his contribution about how apologies were offered at his time as a journalist. And the time limits in the bill as well need to be paused to allow that alternative resolution to take place. A number of people talked about the Derbyshire Principle, where public bodies cannot be sued, and the balance between private companies that are carrying out public services, and that they need close scrutiny as well. And I think John Finney brought that really tangibly to mind when he talked about ferry companies in the Highlands and Islands. Calmac, the publicly owned ferry company, is being held to a totally different standard than Serco, which is a private company, but both are delivering public services. Both are ferry operators and both are publicly subsidised. So there has to be a balance where people doing the same kind of work are subject to the same scrutiny and protection, and indeed protections. People talked about malicious publications, and there were concerns that the lower defences for malicious publications could create a loophole in the law where people could move to sue under malicious publications as opposed to in the defamation law, and this would allow them to take this action. So there was debate about whether serious harm should be part of the threshold for malicious publications as well, so that people couldn't use that. I think it was Liam Kerr that made the point that the threshold was extremely low for malicious publications, and that needed to be tightened up. Presiding officer, we have to try and strike the right balance with this legislation. A number of members, I think it was Annabel Young, that said we need to look after right rather than might. And it's also about freedom of speech versus people being viciously and maliciously damaged. I think it was James Kelly that said that. We need to strike a balance to make sure that there are the right protections in law, but that they cannot be spuriously used to shut down freedom of speech and indeed publishing things that are in the public interest. I think we are a way to getting that, but I believe that the Minister and the committee will work together at stage 2 to strike that balance.
Thank you very much, Ms Grant. And I call Margaret Mitchell, close to the Conservatives. Ms Mitchell, please.
Thank you. Deputy Presiding Officer, the law of defamation was reformed in England and Wales in 2013. In Scotland, the last time defamation law was considered was 1996. Given concerns about the restrictions on investigative journalism and the advances in technology, the internet and social media, in 2017, the Justice Committee decided to include in its work programme evidence sessions in Scotland's law on defamation in an effort to ensure it was fit for the 21st century. In January 2018, the committee received a briefing from the Scottish Law Commission. Following that session with Lord Pentland, it was clear to the committee that defamation law in Scotland was decidedly in need of reform, and the Justice Committee actively considered using its powers to introduce the necessary legislation. However, the process for committees to introduce legislation is complex, and consequently very few bills and our committee initiated. I believe this is an area where it would benefit from review in the 6th session of the Scottish Parliament. The committee therefore continued to press the Scottish Government on the need for defamation reform at the conveners group question session and with the First Minister when taking evidence from the Justice Secretary. Consequently, on the 12th of June 2018, when the committee members held a roundtable discussion with key stakeholders, including representatives from the BBC, Law Society of Scotland, academia, Scottish Pen, we were able to discuss not just the SLC proposals, but even more welcome, the Scottish Government's commitment and confirmation that it would introduce a defamation bill based on these proposals. The aims of the bill are to strike an appropriate balance between freedom of expression and protection of reputation, clarify defamation law and to make it more easily accessible and understood. More specifically, the serious harm test states that in order to bring forward defamation proceedings, the publication of the statement must have caused or be likely to cause serious harm to reputation. The test seeks to prevent powerful interests using defamation law as a tactic or weapon to try and silence unwelcome criticism, discourage frivolous or vexatious actions, and allow the court time to dismiss actions earlier in the process, therefore freeing up valuable court time. Happy to, if I can. Yeah, Andy Whiteman.
I thank Margaret Mitchell for taking intervention. I know the interest she's taken as convener of the Justice Committee, but does she just accept that the reasons why a serious harm test that she's outlined would indeed justify it, were in fact that to be the case? There's no evidence at all that would dissuade committed and determined litigants and pursuers, and there's no evidence at all to save any court time.
Yeah. Margaret Mitchell. Yeah, I'll come on to that, Mr Whiteman, because although that has been asserted, in my view, this happens frequently, and constituents are often sent defamation letters when there's no case to answer, and it's these people that I think the bill would protect. Anyway, however, concerns were raised about the potential chilling effect that has been raised by a number of members, with the onus being placed on the pursuer to prove the statement was not only defamatory but also caused serious harm. And some argue this places an additional barrier not only as intended to those who might bring forward vexatious claims, but also those who may have a perfectly valid case. And whilst I note the faculty of advocates considered its introduction to be inappropriate, I do support the inclusion of the serious harm test. For despite, as I've just said, the Law Society of Scotland's practice rules, solicitors' letters are being issued threatening individuals with defamation procedures where there is no valid case to pursue. However, here, given the opposing views, and including Andy Whiteman's, the Justice Committee is right in supporting the serious harm test inclusion to ask the Scottish Government to set out why it considers the serious harm test is required. Furthermore, the committee's key recommendations include support for a statutory definition of defamation, the codification of defences, the exclusion of secondary publishers from liability, and a time limit reduction from 3 years to 1 year, with discretion available to courts to extend this time limit being confirmed. This would allow individuals to pursue a legitimate case after 1 year if, for example, a defamatory statement in a job reference was not discovered for a period of time. On a personal note, I very much welcome the inclusion of Section 33, which states that the time taken to pursue any mediation will be disregarded. This ensures that parties are not discouraged from or penalised for seeking to resolve the dispute out of court. Here I hope Liam Kerr's concerned that, as drafted, despite the stated policy aim of the section, other forms of ADR, in addition to mediation, do not appear to be provided for, will be addressed. In conclusion, Presiding Officer, there are still details and clarification required at stage 2, such as clarification of the Derbyshire Principle, legal provision of pre-action protocols, and removal of defamatory material from social media and the internet. I am nonetheless delighted that this long overdue legislation is likely to pass its stage 1 hurdle this evening, and that we are a step nearer ensuring defamation issues in Scotland and in the 21st century in which we all live are properly addressed.
Thank you very much, Ms Mitchell. I now call Ash Denham to close for the Government. Minister, please.
Thank you, Presiding Officer. And I'd like to thank members for their contribution to this afternoon's helpful debate. And I'm pleased that there is support across the Chamber for the general principles of the bill. The Scottish Law Commission's reform project was the first significant look at defamation law here in Scotland in a generation. And the way we communicate and live our lives has changed beyond recognition in that time. And the Commission made its recommendations and the Scottish Government agree with them. And given the fundamental rights that this bill will affect, I would like to achieve as wide a consensus as possible across this chamber. And so in answer to Gordon Lintart's question that he posed earlier, I think the answer is yes, the Parliament is up to the job. I've listened very carefully to the views of members, and I would just like to assure everyone that I will, of course, reflect very carefully on what has been discussed today. Serious harm obviously was something that was discussed extensively by a number of different speakers, and before I make my remarks on this, I would like to say to Andy Whiteman that obviously he has a particular experience to bring in this area. He made quite a passionate speech during the debate, and so I'd like to offer him an opportunity to meet with myself and my officials so that we can discuss this further. The Scottish Law Commission took a wide-ranging look at the Scots Law of Defamation, made a number of recommendations for a reform, and among those was that there should be a threshold test for serious harm. And I understand the view that a number of stakeholders have made that it was introduced for the perceived problem of vexatious litigation, that isn't really a problem in Scotland. But I recognise that view, that although there are a few reported cases of defamation here and that it's not a problem, I also consider that it's right that if a person says their reputation has been damaged, they should be able to show how it has been damaged. And I don't think the current presumption that damage has been done achieves that appropriate balance that the bill is aiming to achieve overall. Why should we continue to allow legal action to be raised in a case where no real harm has been done? And that's a question for, I think, the Chamber to reflect on. We've heard today about the chilling effect of defamation law on freedom of expression, and I think that was described particularly well this afternoon by Rona Mackay. The threshold test will give confidence to those who have received a letter, as mentioned by Margaret Mitchell, about possible defamation proceedings against them. And I do take on board, which came through loud and clear from a number of members, the convener and Liam Kerr and others, that the Scottish Government should say why it is required. And I think one argument for that is that failure to provide a statutory test would fail to take into account fully the implications of Section 1(1) of the bill, that communication of a defamatory statement to a third party. So we've heard that because of this change, it's open to the court to develop the common law threshold test, and it's likely that they would go on to do so. So using the test that we have, we can obviously take advantage of English jurisprudence on this issue. That would then provide us with more certainty, and that alternative would, given the number of cases that we have in Scotland, which is quite low, be, if we didn't do that, it could be quite a prolonged period of uncertainty to build that up. So I think what I'll do on this issue is I'll write to the committee and I'll reflect on what's been said today, and I'll put that into writing and send that to the committee in the next few weeks. The Derbyshire Principle was also mentioned by Rhoda Grant and the committee convener, and the aim of this provision is to place on a statutory footing in Scotland the common law principle of England and Wales that public authorities cannot raise defamation proceedings. Public authorities have a reputation, but they need to protect it with political means and not defamation law. And there is a public interest served by allowing unrestrained comment on the actions of democratically elected bodies. And this is the fundamental rationale behind the Derbyshire Principle. As far as I'm aware, no similar case has yet been decided in Scotland. And I'd like to be clear on one point, that the bill will protect those who criticise public service delivery, even if it is delivered by a private body. And the defences of honest opinion and publication on a matter of public interest are powerful defences that will protect speech on this issue. And we shouldn't forget that a private body delivering such services will have to prove that a defamatory statement has caused serious financial loss. And those who criticise public services provided by private companies are sufficiently protected by the provisions in the bill. But on the drafting of Derbyshire, a sensible and a flexible definition, as I mentioned earlier, has been used that doesn't seek to expand the common law boundaries of the principle. And the bill captures those obvious public authorities like local authorities, the Scottish Parliament, Scottish ministers and agencies of the Scottish Government. But the flexible approach will also allow courts to deal with those more complex and nuanced cases. The drafting borrows from Section 6 of the Human Rights Act of '98, which has been discussed by the courts for over 20 years and will provide practitioners with a good base from which to advise their clients. And here in Scotland, the Lord Justice Clerk, Lady Dorian, recently discussed Section 6 in the case of Ali versus Serco Limited, providing guidance on how it should be interpreted. But I do recognise that there have been a range of concerns expressed about the drafting approach, and so I'm happy to reiterate the commitment that I made earlier to working with members of the committee to hopefully find an approach that we can all agree upon. Malicious publication.
It'd be good if you could keep talking till 17:05, which is decision time. So you need to rush.
I'll do my very best, Presiding Officer. Malicious publications is another area that was mentioned a number of times from different speakers. Liam Kerr mentioned it in his contribution, and Rhoda Grant also mentioned it in hers. I've already mentioned that the bill reforms a closely related cause of action, and that is the malicious publication. But in order to succeed in a malicious publication action, the pursuer must show that the statement complained of was made with malice, and the definition in the bill is the same as that in the common law for similar types of action. But again, I do recognise the committee's views on this matter. I recognise some of the reflections that have been made in the chamber this afternoon, and that's why I'm very happy to bring forward an amendment at stage 2, which hopefully will reflect those recommendations. So, in conclusion, Presiding Officer, I believe that today's debate reinforces the impression that there is broad support for the bill and its policy aims, that as a whole this bill seeks to very carefully balance the law. As members have indicated, though, there is a difference of views on some of the detail, and I am willing to work with members to make sure that this bill is something that we can all, as far as possible, agree on, because I think that is very important. I'd like to thank members who've contributed to the debate today. I'm very pleased about the support for the general principles, and this bill is an opportunity for the Scottish Parliament, obviously, to consider freedom of expression in modern Scotland. But this right comes with responsibilities, and it should not and must not be used to unfairly damage the reputation of another. We must all be careful, however, that in seeking to better protect individual reputation, we don't unintentionally inhibit free speech. The law of defamation is the way we balance these two rights, and I look forward to working with the committee and members across the chamber in making sure that we achieve that appropriate balance for modern Scotland. Thank you, Presiding Officer.
And thank you, Minister. That concludes the debate on defamation and malicious publication Scotland Bill. And it's time to move on to the next item of business, and that is decision time. And there's only one question to which we now come, and there's only one question to be put, and the question is that motion 23243 in the name of Ash Denham on defamation and malicious publication Scotland Bill be agreed. Are we agreed? Yes. We are agreed, and that concludes decision time, and I close this meeting of Parliament.